All right, well, thank you everyone for coming this afternoon. So it's my pleasure to introduce one of our best pro bono partners, the National Immigrant Justice Center. Many of you have cases or are working on cases with us now. So we have Ellen Miller and Rachel with us. So I'm sorry, Rachel, your last name? Milos, that's right. And they're going to talk for about an hour and give us an overview of the various opportunities that they have for you to do pro bono work. It's not just asylum. We do a lot of asylum work, but there are a number of other projects as well. So I'm going to turn it over to Ellen and let her tell you.
Well, again, thank you all, and thanks, Sandra, for making this happen. And I know Julie, too, who is here at the firm, has been really instrumental in our relationship. And so we thank you, Perkins, for everything that you've done and being stellar partners. And we're glad to have the opportunity to come and speak with you this summer amidst all the chaos in the immigration world, right? So my name is Ellen Miller. I'm the pro bono manager at NIJC, and I work across the different projects. We have approximately 9 projects that offer pro bono opportunities at NIJC, the National Immigrant Justice Center. And so I'll briefly speak about those and some of the ways that we network with the pro bono community here in Illinois, Indiana, Wisconsin, and extending more into other states. And then Rachel's going to talk to us a little bit about Asylum 101 and just the basics of what is asylum, what's going on, and why we really need the support. So the National Immigrant Justice Center is an entity of Heartland Alliance. If you're aware, Heartland Alliance is a major organization here in the Chicagoland area providing health human services for a variety of populations. We provide immigrant legal services, and we basically do this through 3 pillars. The first it's not an order, right? But one of the pillars is our legal services. And in the last year, we've provided over 10,000 legal services on matters to non-citizens here in the Chicagoland area. And we largely do that through the support of our pro bono attorneys and our network. So while this slide here says that we have approximately 1,600, we just closed out the fiscal year, and I will concretely say it's well over 1,800 pro bono attorneys now, with approximately 150 different firms, corporations, solo practitioners. So we're really, really lucky and blessed to have the support of the community, and we do see it as a partnership to provide services such as the DACA renewals, family petitions, asylum. We work with trafficking, survivors and victims of trafficking. We work with VAWA and U visa cases, dealing with individuals who are survivors of domestic violence or crimes here in the United States. So there's really a wealth of services that are provided to individuals at 250% below the poverty line. So we're working with a really special population here that might not otherwise have access to legal services. And this is within our direct representation. We also have a pillar that looks at advocacy and education of decision makers. And so as we know, some of our policies and our laws are under attack, or they are being challenged. And we have an opportunity to really, with the experience that we get on the ground, go up to decision makers and say, this is what's happening. This is how it's impacting our communities. This is how it's impacting the safety of our society and our legal system. And so what's it really doing to due process, to constitutional rights and the rights of all individuals here in the United States. So we have an office out in D.C. With 4 to 5 individuals who are running like crazy all over the Hill. And then we also have an individual that is working networks here in Illinois and spends a significant time in Springfield. Actually, we just signed with Pritzker today or yesterday 2 new bills passed here in Illinois, which we've been instrumental on. So it's really exciting to be able to come in at that angle also. And then last but not least, we also work in federal impact litigation. So looking at the larger structure and how can we challenge the laws and uphold the laws in the higher courts. What is lovely and an honor to work with NIJC is that with NIJC, when we do take up impact litigation, we also guarantee the individual's representation on their underlying claims. And I think this is really nice that we have this integral service where the immigrant is protected and provided for at all stages of their legal journey. So who are our clients? The bottom map here shows just from fiscal year 2018 where our clients come from, and where they have roots and where they are still have their heart and their head a lot of times too, where some family members remain. As you can see, they really come from all corners of the world. They speak all different types of languages, have different levels of experience, and then they're coming to our country for a variety of reasons, and requesting protection or requesting the right to stay through legal means. The top map here is where we have most of our partners, and so as you can see, we have partner organizations, pro bono partners in all corners of this country, really working to uphold due process and access to justice for the immigrants that we come into contact with here in the Midwest. Who are NIJC clients? So currently we have a list of clients that need representation, and that list for the last couple of months has hovered around 60 cases that we're looking to constantly place with pro bono attorneys. I will say that the list does not get smaller despite us working very diligently to place cases and the pro bono networks really stepping up in this time of need to take the cases. It has not gotten smaller, the need's just gotten larger. So the need is getting larger and our pro bono networks is also getting larger and the numbers are staying the same. So legal services, legal skills are really being put to use, and it's a great skill to have right now. So we work with unaccompanied immigrant children. We work with families. Our family integrity project that started up last year in response to the family separation continues to go down to Laredo and fight cases, goes to Texas, and we're really working with families all over the country. We work with non-detained and detained individuals, also LGBT individuals from the LGBT community. All of our clients, most of our clients reside in Wisconsin, Indiana, and in Illinois, and are committed to traveling to Chicago to meet with their pro bono attorneys. We do have, like I've mentioned before, a number of clients along the border region, and we actually just opened an office in San Diego. And so we're working with a detention facility and a couple specific issues in San Diego. Our clients, I think, though, more importantly, are fathers, their mothers, their students, their lawyers, their activists, their religious leaders, their business people. So they come with their different levels of experience and their education levels, and they're really looking to provide a life for themselves and for their families here. It is an honor to work with these individuals, and I know that we learn a lot from them as well. Why are pro bono attorneys important for immigrants? In the United States, non-citizens have the privilege of representation, but it is not a right. So there is no right to appointed counsel for immigrants in the immigration proceedings. One judge once said it's kind of like being in a traffic court with the amount of cases going through and how quickly they move through, but it's with a death penalty hanging over at the end, with a sentencing possible at the end. And so immigration court is difficult, it is complex, and the right to counsel, as we'll see in the next slide, is very important. So we work with asylum seekers and individuals that have suffered trauma, that have suffered acute situations of trauma, but also prolonged situations of trauma, toxic stress, being neglected or just not having the right access to certain, nutrition or access to services, and that affects their ability to communicate, that affects their ability to advocate for themselves. And then also we work with individuals that might have a lower education level, or that might not be able to read or write in English, let alone their own language. Working with children, of course, as you might have seen from some of the videos or the memes, it's also particularly compelling when your client can't even touch the ground because their 3-year-old little legs are dangling from the chair and the headphones won't fit on for an interpreter, that they have really no idea what words they're using. So really, we're dealing with very vulnerable people or people in vulnerable situations who do not have the right to have someone help them understand what could happen to them. And this is why pro bono attorneys play an important role. So we see here too, that lawyers do make the difference. The statistic on this slide is a little bit outdated. I need to update it. We actually do have statistics up until 2017 that remained rather similar, showing that with representation, 74% of cases with representation have obtained relief, whereas 13% without have obtained relief. That's pretty stark comparison. That's a pretty stark number right there, right? And so where this also makes a difference is right now in the asylum world, across the country, the approval rates of asylum hover around 40%. Here in the Midwest, not all of our clients, but NIJC maintains an approval rating of approximately 90%. So we're really rocking these cases. We're rocking the courts, and we're saying this can be done. And as you might have seen, and Rachel's going to talk about this a little bit more, but last year when former Attorney General Jeff Sessions mentioned that domestic violence is no longer a viable claim for asylum, we at NIJC quickly turned around, I believe it was in 24 to 40 hours, and had guidance for our pro bono attorneys to say, in fact, this is not true. It is still viable, and we continue to win these cases, and we continue to show the Seventh Circuit and all the courts here in this district, in this jurisdiction, that these are in fact viable claims. And so we are at the forefront of supporting, upholding the law, challenging any challenges to these laws, and then also supporting our pro bono attorneys to make it happen with all of these clients. So how can you get involved? Pro bono opportunities at the National Immigrant Justice Center, like I mentioned, we have approximately 9 different projects that offer opportunities. Some of them are quick administrative processes, which I know pro bono attorneys really like, such as the DACA renewal. Citizenship applications actually were once quick, are now becoming more complicated. And we have the VAWA and U visa and asylum right now, though I don't want to use the word detain, but I will stop myself on asylum because that is where our biggest need is right now. With asylum cases, general asylum cases, detained asylum cases move rather quickly. Children, LGBT individuals, individuals that have suffered domestic violence and are persecuted for a variety of reasons. Asylum cases can take a long time. We say anywhere between 40 and 200 hours, which might seem daunting. When you pair up with a colleague, however, and you win that case, I will say that a number of pro bono attorneys have said, I probably would never have taken a case unless my partner hadn't thrown the case on my lap. And then they say, but I'm so glad they did because it's changed my life. So where there is an investment, we like to think that where you invest, you also get something out of it. And so there's a lot to get out of an asylum case also. And we look to make that possible and as easy as possible throughout the process. So this process, it does start with an immigrant approaching NIJC, and we do an extensive intake with them. We go through and get a brief history. We start to collect documents. We vet them extensively in terms of, is this claim viable, but also looking at credibility. A lot of issues with credibility comes up in the court and along the process, and so we really look to see if this is a person that we can move forward with in a legal case and also with a pro bono attorney. Once we've determined that, then we actually sign a retainer with the client. So the client is also our client. We only take on as many clients as we can represent. Obviously, then we hope to place them with a pro bono attorney, and this expands our ability to continue to provide legal services. So we do maintain a model. We have a small internal staff, and then we have an extensive pro bono network to really make these services happen. That said, I will say that for the past I've been at NIJC almost a year, and during that entire year, we have had to suspend our asylum intake because we can't take more cases right now. So we need to just keep pushing these forward with pro bono attorneys and expanding our networks, and we really appreciate it. But we hope to soon reopen that intake, but we cannot because we can't make false promises, right? And we need to make sure that the representation remains of quality for these individuals. So once we retain the individual, we'll continue to work on their case until we can place them with a pro bono attorney, and then the pro bono attorney will get them at any point in that process. Obviously, we hope to get them with a pro bono attorney as quickly as possible to establish that relationship and start that work. Along the way, we do offer a wide range of resources. We have manuals, which I understand from our community are greatly appreciated. They're very practical and providing up-to-date. We update them on a very regular basis. Thanks to the changes this administration has given us, we get to update them more frequently. We have webinars online. This will be one of them. We have brief banks where we give examples and samples. For LGBT cases specifically, we have a really deep bank of country conditions specific to LGBT cases. We've recently redone, and I'm very excited about our new FAQs and tip sheets, working with clients, working with interpreters. What happens when we win? What about work authorization? So really trying to facilitate these questions for attorneys that are trained to research. You have this information at your hand. And then, of course, if you can't find it in the manuals, if we haven't already exported as much as possible into these documents, NIJC attorneys like Rachel are available with a phone call or an email to answer those really case-specific questions. And so then finally, what do we expect of our pro bonos, and how do we hope that this partnership can look? Like I mentioned, NIJC provides general trainings. An asylum case, we'll start with an intensive 3-hour training where we go through the different steps of the asylum procedure, the process, what to file, how to work with clients, basic tips. And then, like I mentioned before, we have all the resources available. We do provide review of drafts, and we ask you, because these are also our clients, we ask that you share your drafts with us in a timely fashion so that we can help on strategy and just make sure that we maintain good case law here in the 7th Circuit and that we're collaborating in this way. Like I mentioned, we have examples and samples, policy updates, so as things change quickly, we do our very best to stay on top of that and provide you the most up-to-date information also that is reliable. And then we remain of counsel throughout the case. That said, once a pro bono attorney is on board, it is the responsibility of the attorney, the pro bono attorney, to create the case, to prepare the documents, to write all of the briefs and the motions, and present the client. So it is the pro bono attorney's case with the client to work up. The attorneys are also responsible to provide interpretation when needed. Expert opinions such as forensic evaluations, psychological evaluations, and such is also the responsibility of the pro bono attorney or firm. And then, of course, the client. We can't forget the client in this process. So the client is, we work with the client as well as you do to tell their story, to communicate, to advocate for themselves, and really know how to present their case in the best light. And then the client is also responsible to update you, as some of these cases may take a couple years, on any updated circumstances such as change of address, phone number, an extra kid, one less spouse, or anything like that, okay? So it is a 3-way partnership that kind of ebbs and flows throughout the journey throughout the process of the case. All of that said about the process, I do want to just show too, and yesterday we had a wonderful awards ceremony with the CBA and CBF of all the pro bono attorneys that have won these cases. And I'm proud to say that of a number of the 5 recipients actually said that their work with NIJC has really been a highlight of their pro bono experience. And so these are just photos of some pro bono attorneys with their clients after they've won and obtained relief, and where the case may have originally been thrown on your lap or on your desk or pointed to you. You can see the smiles here, and some of the stories are fabulous, just from the client and also from the attorney to say, we did this. And so it's a beautiful journey, and we're excited to have you join us. That said, before we get into the asylum part, does anybody have questions about pro bono opportunities or NIJC in general? See none? We're going to have Rachel come up. Thank you.
Hi. So again, I'm Rachel. I'm one of the attorneys on staff at NIJC on the Asylum Project. So I'm going to kind of just give you guys some basics on asylum if you're not familiar with it already, and hopefully you'll be interested and want to tag team with some colleagues on a case yourself. So asylum, the definition of asylum, in order to be eligible, you need to be considered, need to meet the definition of a refugee. And a refugee is defined in the Immigration and Nationality Act as a person who is outside their country of nationality, who is unable or unwilling to return to their country and unable to avail themselves of protection in that country because of persecution or a well-founded fear of future persecution on account of one of 5 protected grounds: race, religion, nationality, political opinion, or their membership in what we call a particular social group. And I'll talk a little bit more about that as we go. When we bring an asylum claim, we really break it down into elements that we need to prove in that case. The first one is that our client needs to have a well-founded fear of persecution. That persecution needs to be perpetrated by the government or by an entity that the government either cannot or will not control. And then the persecution needs to be on account of one of these 5 protected grounds that we mentioned before. There's 2 ways that people can seek asylum here in the U.S. On the left-hand side, you can see something called the affirmative process. And that happens when a client comes here legally. Let's say they come on a visa, maybe a tourist visa, maybe on a work visa. They come into the U.S. maybe for that purpose at that time. Maybe they're here just for a visit, but then something changes back in home country that makes them afraid to return to that home country. In that situation, the client will affirmatively apply for asylum here. They're not in court proceedings. They don't have, they're not being ordered to appear in court. They haven't been apprehended by immigration officials. They basically are just going to file this asylum application that's called the I-589 at the asylum office. And then what will happen in that process that you'll see is that they'll file that application. A couple weeks or months later, they will be called into the asylum office for an interview where they'll sit in just a basic office with an asylum officer, and they'll tell their story and they'll explain why they're applying for asylum and why they're eligible. That asylum officer will either grant their application, and so they will be able to be an asylee and work towards legal permanent resident status here in the U.S., or their case will be referred to court proceedings. And then the process will kind of start all over again, where they will again have an opportunity to present their case before a judge in court in what we call a merits hearing, which is basically just like a court hearing, kind of more like a trial. The other way that people can apply for asylum is the one that I think we think of a little more commonly, where individuals are coming, sometimes they're presenting at a port of entry, sometimes they're coming across the border without, inspection, and they're being apprehended by immigration officials. So sometimes they're having that contact there, where they're getting picked up by CBP, Customs and Border Patrol. They are then issued something that's called a notice to appear, which is a document that places them into court proceedings and tells them that they need to show up in court. It also charges them with, you came here, you didn't have authorization to come to this country. And then at that point in time, the client will say, you're right, I came here, I didn't have a valid visa to come to this country, but I am, as a defense to you removing me and sending me back to my home country, I am eligible for and deserving of asylum here. Yes, question.
Maybe just a comment on had a prior asylum client who came here on a valid visa and put it in proceedings because they didn't believe the reason that she gave at the airport by the customs. So just to kind of comment that there may be a little more fluidity there than it seems sometimes, because I was so concerned about that. I was like, was this right?
Sure, good point.
They did it and they didn't believe her.
Yeah, good point. Good point. Yeah. So, and one other kind of, you see the red circle over there that talks about children. They're sort of in a unique posture. So we call them unaccompanied immigrant children. If children are coming here without a legal guardian or a parent, they're going to be picked up by immigration officials. They're going to be put into what we call the Office of Refugee Resettlement, into a shelter there. At that point in time, they are going to again be issued this notice to appear, which is going to put them into court proceedings. But instead of kind of forcing the kids to go straight into court, because it is such an adversarial process and it's not a very friendly venue to children, they are first allowed in some instances, that law is changing a little bit, but in some instances they're allowed to have their first opportunity to apply for asylum at the asylum office and to have an interview with an asylum officer there. Again, if they are not successful at the asylum office, they then get kicked over and referred to court, where they have a second bite at the apple and a second opportunity to present their asylum case there. When you get into court proceedings, there's kind of 2 different types of hearings that take place at the bottom. The first we call a master calendar hearing. That's basically just like a status hearing where you show up with your client, you basically bring out that notice to appear document, you plead to those allegations. They just say, you are a citizen of Guatemala, you are not a citizen of the United States, you entered on or about this date, you didn't have a valid visa to enter at that point. You're going to plead to those allegations. You're going to concede that you're removable from the country, but you are then going to assert that your defense to removal is that you are eligible for asylum. At that point in time, you're going to get a merits hearing date. And that merits hearing, as I mentioned, is kind of like your court hearing where you have an opportunity to put on a case. You're going to, be put on as a witness in trial. You're going to present your testimony. The government is going to have an attorney that's going to cross-examine you. You're going to be able to introduce other evidence and other witnesses to support your claim. And then the judge at that point will issue a decision in your case. Any other questions on that? So in terms of what you're going to file when you're preparing an asylum application, this is a big old list of stuff. So I'm not going to go over it now because it's not really relevant and we're not going over it. But ultimately, in both venues, you're going to have to file different types of documents because at the asylum office, it's governed under USCIS, the United States Citizenship and Immigration Services. And over here, it's governed by Immigration Court, the Executive Office for Immigration Review. So if you're appearing as an attorney in front of USCIS, you have to file what's called a G28. If you're appearing in front of the Immigration Court, you have to file what's called an E28. So the reason we put these things on a list and we have this checklist is because if you file a G28 in court, you lose. If you file an E28 with USCIS, you lose and you're in trouble. So we just want to make sure everything is nice and clear. And then you can kind of have this little checklist when you're getting ready for your asylum case, you can kind of go down the list and make sure you've got all your bases covered. Basically, when you're preparing an asylum case, you enter your appearance as attorney for your client. You file what we call the I-589 application, which is a basic application for your client, which basically just goes through biographic information about your client and then very basically lays out the reason that they are claiming asylum. Maybe it's because they were persecuted because of their religious beliefs in their country. Maybe it was they were persecuted because they had political opinions that were contrary to that of the government and they were arrested and imprisoned and tortured because of those things. Maybe it was because they were horribly abused by their domestic partner and the government and the police refused to take any action to protect them at that point. So whatever the grounds are for their asylum claim, you're going to lay those out very briefly in that application and you're going to file that application. After that is done, and when you're either getting ready for your asylum interview or you're getting ready to present your case in court, is when you're going to do the meat of the work, which is number one, critical, most important, preparing an affidavit for your client, which is their story, which is going to really explain, give context about their life, what happened to them, why they needed to flee that country, and why they are still afraid to return to that country. And then you're going to also have to provide a ton of supporting documentation to corroborate that story in any way that you can. If your client sustained a lot of physical injuries, you're going to try to find hospital records, police reports, photographs, get a forensic medical exam. If your client was home when the police came and arrested them with 3 of her family members, you're going to try to get in touch with those family members and get affidavits from those family members. So really, you're just putting all these things together. And then because we're attorneys, we get to write a memo or a brief where we get to argue that your client is eligible for asylum by sort of going through each and every one of those elements that we talked about previously. We also like to include an annotated index because it's pretty and it makes it easy for the judge to quickly go through the pages and pages of documentation and country conditions evidence that you're going to introduce in order to support your asylum claim and really pull out those key critical pieces of information and put those right up front. And right now it's free. There's no filing fee. That might change under our current administration, but right now it's free. So top 10 things that you should know if you're going to take an asylum case or start working on an asylum case. Number 1, don't believe everything you read. So there's been tons of press, tons of news about asylum lately, and I think that depending on where you get your news or what you hear, it's hard to know what the truth is anymore, and I think things are so quickly evolving and changing, it's also hard to keep up with things. So number 1 is the myth was the asylum ban has eliminated asylum protection for asylum seekers who come across the U.S.-Mexico border. So initially, Trump did come out with a policy memo that was an attempt to bar basically all people who did not enter at a port of entry, so just kind of entered without inspection across the border, from getting asylum, period, or requesting asylum. There's a temporary restraining order in place right now, thanks to some litigation, so we have to kind of wait and see how that's going to play out. But currently, there's a restraining order in place, so that is false. Number 2, Central American asylum seekers are required to first seek asylum in Mexico before requesting asylum in the U.S. Again, just recently, a couple days ago now, Trump came up with this third country rule, which basically says that if you're attempting to apply for asylum at the border, you first have to attempt to apply for asylum first in another country. ACLU and the Southern Poverty Law Center immediately came out with some litigation to try to stop that and block that from happening. So again, we're in wait and see time right now. We aren't sure where that's going to go. We're hoping that it's going to be false, right? Number 3, asylum seekers must not wait in Mexico where their asylum claim is adjudicated in the U.S. Unfortunately, that is partially true right now. So at certain points of entry, they've started implementing this procedure where basically if people are coming in, and I can't remember, I know there's 2 in Texas and there's 1, I believe it's in San Diego right now. If people are coming, they say, I'm seeking asylum, they send them back to Mexico to wait before they can have those hearings. The problem this is creating that I'm sure you've heard about and read about is that conditions are horrific in Mexico. It is not safe. As soon as people are dropped back off in Mexico, those people are being kidnapped. There aren't enough shelters for people to stay. I mean, they're horribly dangerous to the conditions to the point that asylum officers who adjudicate these claims filed an amicus brief in pending litigation to stop this practice from happening. So we will see what happens in the future. Again, there's litigation happening on this front. There was an injunction that was in place. The Ninth Circuit overturned that. So currently, I want to say there's another, it's going up to another branch of the Ninth Circuit to review that again. So we're kind of waiting again to see what's going to happen there. And then finally, matter of AB, which Ellen referenced and alluded to. This was a case that came out in June 2018. That was a decision by Jeff Sessions, where he basically said that in dicta, that domestic violence claims and gang violence claims are no longer viable for asylum purposes. That is totally not true. We've had a ton of wins on gang violence and DV claims in immigration court since that ruling came down. And actually, Ashley, who is my boss, came up with a number of other NIJC staffers with a memo specifically on this that's about 30 pages long that gives you all the information that you need to attack and to fight those arguments. That matter of AB forecloses these types of claims. So read that if your case that you are going to work on or that you are currently working on hits on either one of those issues, because you're going to want to directly address that case head on. So asylum, the burden of proof and what you need to prove if you are going to be eligible for asylum is that you have to show that you meet all of those elements and that you were harmed in the past. If that is the case, then there is a presumption that you are going to be harmed again in the future if you return to that home country, or you can show that there's a reasonable possibility that all of those elements that we talked about, that you suffered persecution or that you will suffer persecution by the government or by an entity that the government will not or is unable to control because of race, religion, nationality, your political opinion, or because of your membership in a particular social group. You have to show that that's going to happen in the future. The Supreme Court has said that a reasonable possibility is a 1 in 10 chance of persecution. So this is a low standard that you need to meet. This isn't a probability. It's just a 1 in 10% chance. But it's still, as the asylum applicant, the burden is on you to show that there is this reasonable possibility that you will be harmed again in the future. So how are you going to do that? When we put up this slide here, because a lot of times I think asylum in the past has had this connotation that it's political only in nature, that asylum is something reserved for political opinion types of cases. But really remember that you can get asylum if you fall into any one of these protected categories. If you've been persecuted because of your religion, your race, your nationality, your political opinion, or what we call membership in a particular social group. So race has this broad meaning. It doesn't, it's not just straightforward. It can be sort of race and nationality, ethnicity, all those things kind of commingle and work together. And you can kind of be creative in terms of the arguments you're going to make there. Religion or lack of religion. Nationality can be citizenship, ethnic group, tribal group, a linguistic group that you're part of. Political opinion can be an expressed political opinion, or it could be your dad was an active political member of a certain group, and they believe that because your dad was a member of this group, you also hold that same political opinion, even though it could be totally not true at all. And then finally, membership in a particular social group. This is where actually most of our clients fall into this category, and it's also the most complex and the most nuanced. So we'll talk about it in a little more depth. So a particular social group has been defined by the Board of Immigration Appeals in this case called Matter of Acosta from 1985 that is still the test in the Seventh Circuit, which is the law that applies to us. is a group that's based on a common immutable characteristic that either members of the group cannot change or they should not be required to change because it is fundamental to their identity and their conscience. So the way that they came up with this definition was they said, well, your race and your nationality are things that you can't change. So that's the first part of the definition. And then they said religion and political opinion are things that you should not be required to change because they're fundamental to your identity or conscience. So they lumped those things together, and that's how they came up with this definition. And the way that we normally base our particular social groups is we base it on things that we know people either can't change or they shouldn't have to change. So your gender can't change, nationality you can't change, your relationship, if you're married to someone, if you're part of a specific family. Also, past actions can qualify as a ground for a particular social group because that's something that you can't change. So let's say that a gang member tried to recruit you on a number of occasions and you refused. Only after that point, the gang member started targeting you and beating you up and threatening to kill you. That past action of your refusal could constitute a ground for your particular social group. Another example would be, let's say your sister, a gang tried to take her and wanted her to be the gang's girlfriend. And she said no, and she escaped. After that, those gang members started targeting you and your mom and your dad. They did that because of your relationship to your sister. So this is the way we sort of think about how are we going to formulate those PSGs. The persecutor we talked about. So the persecution either had to be perpetrated by the government or by a group that the government cannot or is unable to control. So most of the time, if you can, you want to argue that the government was the persecutor. And we take a really broad look and a broad definition of persecutor because that makes your life easier. Then you don't have to prove that the government was unable and unwilling to control. So it could be the military, it could be security forces, it could be the police, it could be the mayor, but sometimes people are able to argue that if it's a gang, if the gang is effectively completely controlling a neighborhood, maybe collecting taxes as people enter or exit the neighborhood, maybe effectively is like collaborating with the police, has infiltrated the police to such an extent that they effectively are serving as government agents, sometimes people will try to make that argument on that ground. Otherwise, you have to prove that the government is unable and unwilling to control your persecutor. So a lot of times we know that gangs, cartels in Central America are rampant. There's horrible corruption. Mexican police are afraid of cartels, so they won't do anything. They won't take any action. Sometimes they're taking payoffs. Sometimes they're afraid of retaliation against their own family members if they were to take any action. So in those instances, you're going to rely on statistics, on country conditions evidence that you find to really demonstrate that, hey, 97% impunity rate in this country indicates that the government is unable and unwilling to do anything about this gang activity in this area. If you have abusive family members, maybe there's horrific domestic violence, and your client has gone to police and tried to get a temporary restraining order, and the police have laughed her off and told her to go home, and it's a family matter, and you do what your husband tells you type of thing. Again, that's an instance where she actively, affirmatively tried to seek help from government actors, and they refused to do anything to help her. Yes? Great question. So what we do a lot of times is we start with a broader particular social group. We'll start with something like Guatemalan women, but then what we'll say is Guatemalan women who are in relationships they are unable to leave, let's say, because in that situation, she's in this situation, she's tried to leave, she's tried to seek help and assistance, but she can't do so because she's controlled by that abuser. Credibility. So this is the critical part of your case, is convincing the immigration court or the asylum officer that your client is credible, that their story is a believable one. And so you are going to spend the bulk of your time working with your client, preparing an affidavit, working to prep them with testimony if you have a court hearing, making sure that everything in their story makes sense. Oftentimes, we recommend that people do what we call a FOIA request, a Freedom of Information Act request, where you kind of get all the information from immigration so you know what all of their previous contacts with immigration look like so that you can compare those documents and those materials with one another and just make sure that everything is consistent and tracks, because credibility inconsistencies are the things that end up killing our cases. So those are things that you really need to do your due diligence on and make sure you check on. On that note, it's really important to understand that our clients, as Ellen mentioned, oftentimes, have fled to this country, left everything they know, left families, left homes because they were afraid for their lives, and sometimes have endured horrific torture, trauma, gang rapes, other types of things that are extremely difficult to talk about. Sometimes they've endured extreme physical abuse, head injuries, those types of things, which also are going to make there be memory issues, cognitive difficulties, difficulty coherently remembering, recollecting, telling consistent stories. So know that when you are working with these clients and you're preparing affidavits, if they tell you two different things or two things that are not identical every single time, that is 100% normal, and that it's going to be your job to kind of work with that client to kind of get to the bottom of what the story is there. Corroboration. So the law says that a client's credible testimony standing alone can be sufficient to meet the burden in an asylum case. However, in reality, the court basically says you need to present corroborating evidence unless you don't have that evidence and that evidence is unavailable to you. So what we try to do is we try to corroborate everything we can on every element of that claim. And the way that we do that is by kind of these four categories that we lump things into right here. So first and foremost, if you're saying police in Guatemala are ineffective and useless and corrupt, you can't just say it. Your client can't just say it. You're going to rely heavily on country conditions documents, State Department reports, Amnesty International reports, Freedom House reports, any different human rights organization, even newspaper reports, and you're going to find as much evidence as you can that support that proposition that you are making. You can also try to find an expert on that country who is from Guatemala, who spends a lot of time in Guatemala, who's on the ground, who can speak directly to that issue. Client-specific information. A lot of times, again, if your client has suffered physical abuse, you're going to want to say, did you ever go to the hospital? Did you ever go to the police? Do you have those hospital records? Do you have those police records? If you don't have them, can we get them? If we can't get them, why can't we get them? Is it too dangerous for your mom to go to the police station and try to request those records? Okay, then we'll put that in your affidavit. But it's your job to try to get as much information as you can to corroborate those aspects of the claim. A lot of times there is no physical damage, no physical scarring from previous trauma, but there's a lot of emotional damage. So what we recommend a lot of times is to try to get clients into counseling, try to get them to talk to a therapist, and then what we'll have the therapist do is write a report for us, especially if we think that it's pretty clear that the client is suffering from PTSD or other sort of mental health issues. Because of that, they will submit a corroborating affidavit that we can submit along with that application, because persecution includes physical harm, but it also includes emotional trauma and suffering. And so that's another element that we need to prove up, remember. Photos, sometimes clients document their injuries, so you're going to want to bring in those photos. And then again, the hardest and most critical part that we need to prove is that there's this future persecution fear. How can we prove that a client's going to be harmed again in the future? Well, sometimes we can get affidavits from family members that are still back in home country that say, hey, they're still looking for Kimberly, right? They were looking for her before, they threatened to kill her before, and they keep coming to the house, and we keep seeing that same truck park in front of the house, and they're still looking for her, and that just happened last week. We would want an affidavit from that person. Sometimes we have other individuals who have fled here, they've been forced to return to home country, and then they've suffered harm again in the future. We can get an affidavit from that individual showing a similarly situated individual, then that's something that we want to introduce as well. And again, expert affidavits, country condition reports are extremely helpful in this respect in terms of proving up the possibility of future harm. Another thing that I kind of touched on briefly before is we always like to think, oh, okay, we're working on their asylum case, and this is the most important thing to this client right now. I'm going to expect them to call me back immediately. I'm going to expect them to collect the documents that I asked them for, and they're not responding. And why isn't this critical to them? So you need to remember that, these people have gone through a lot of horrible stuff. Sometimes they're still really afraid for family members that are remaining in home country. Sometimes they don't have a job. They are just trying to feed their family. They're kicked out of wherever shelter they're living in. They're trying to find a place to live. So really remembering that, if it doesn't seem like they're the most responsive client in the world, that does not mean that this case is not hugely important to them. It is the most important thing to them, but other things are going to be more immediate and they're going to be taking away their attention from that. So just trying to remember to be patient with asylum seekers because they are different types of clients that you're going to be working with. I mentioned the memory issues that can be faulty that are going to require a little more work on your part in terms of teasing out the story from your client. And also just knowing that it's really difficult to talk about horrible rapes and torture and those kinds of things. And to really try to be sensitive to that, even in terms of, are you more comfortable speaking with this attorney, or, you know, what can you do to make your client the most comfortable in those moments? Timing, Ellen also referenced and alluded to. The timing for asylum cases right now is crazy. So at the asylum office, if you basically filed an application with the asylum office before January of 2018, you're still waiting for an interview. It's been 3 years. It's been 4 years. It's crazy. But they started a new policy at the asylum office in January of 2018. So if you filed after January of 2018, you're getting your interview within a month. And you're getting a decision usually within a couple of months after that. So those cases can move very quickly. There's also another kind of case that's called a family unit case, FAMU cases, which are usually mothers with children who have come in and have been placed in court proceedings. And there's been a new policy that's come out where basically they want to expedite those cases and get those through the system as quickly as possible. So for those family cases, we're seeing them go to court for their first master calendar hearing, and they're getting a court date, one for an individual hearing, which is trying to prepare all the things that I've just talked about for you guys in a month or 2 months or 3 months. Usually we like at least 6 months to try to put on a good asylum case for a client, because you want to try to get an expert. You want to try to get all these documents from home country. You want to meet with your client a number of times to prep their affidavit. You want to maybe get them into counseling services so that you can help them be ready to be able to testify at trial. So those cases are getting pushed through very, very quickly, which is challenging. And we're having a lot of capacity issues trying to deal with those cases right now. But then, like I said, other times we've got cases that are pushed way out into the future. Regular asylum cases that are not family unit cases are going into their master calendar hearing, and they're getting dates out in 2021, 2022. So just knowing as you go in that if you take an asylum case or you're working on one of those cases, the timing can vary widely based on the type of case that you're taking. So that's important for you to know in terms of managing your time and your expectations, and also managing your client's expectations about what they should expect in the future. And then number 10, Ellen also referenced this. We basically have a case list. I think we've got about 50 cases in-house right now. We have 4 attorneys. That's a lot of cases for 4 attorneys. And so we had to close our hotline, which means we couldn't take any more. We can't take any more. We can't do any more intakes because we can't take any more cases, because we can't handle any more cases without the help of pro bono support. And that's why we love pro bonos, and we are so thankful for pro bono support, because we couldn't do what we do without you. Every case that you take allows us to take another case. And not only do you help that one client, but a lot of times if they have children or a spouse here in the U.S., those individuals can also be granted asylum along with the primary applicant. And if they have family members back in their home country and they are granted asylum, they can petition for their family to come over as well. So sometimes you're not only helping your client, but you're helping their entire family, which is pretty amazing. I just found out the other day that a client who I got asylum for, I want to say it was a year and 3 months ago, just is going in for his green card interview. And I was like, man, this is the greatest thing ever. And his family came over, and it's a great thing. So anyways, thank you guys very much for your time today. I'll let Ellen finish up here.
Rachel's fabulous. She's like managing all of these cases right now, and she's like, yeah, I got an hour. I got some merits to do, but I got an hour. So I don't know if there's any other questions for Rachel before she runs off. Yeah.
You know, I'm thinking, what is the hearing like? I think it was more like a trial, but like, what does the attorney do? How much oral are you doing? What does that look like?
Sure. Yep. So it's kind of what you think of, where you're going to walk in, but on a much like less stressful scale. The federal rules of evidence don't apply, so everything's faster and looser. You could admit a whole lot more stuff. There's not all the formulaic procedural nuances that come along, I think, with regular court. But you're going to go in, you're going to put your client on the stand, you're going to do a direct. The government attorney is going to have an opportunity to do a cross. Judge can jump in whenever judge wants to and ask questions as well of your client. So you're going to prep for all those things. Additionally, if you have an expert and you want your expert to testify, you can put your expert on. Again, you might have to do some, voir dire in terms of qualifications, et cetera. Do your direct, do cross, those kinds of things. If you have other supporting family members that are there that want to testify, you can do that as well. Merits hearings are usually about 4 hours long, so that's not a ton of time to put on all the information you want to put on. So you need to try to get the trial attorney to stipulate to certain things beforehand, or really just prioritize what's going to be critical and important. You are going to do that big filing beforehand, so the court's going to have everything that it needs before the court. You are going to get to do a closing statement as well to kind of focus on and highlight really key pieces of information if you felt that those weren't fleshed out sufficiently at trial. But that's pretty much it.
I will also say, I think a lot of people, litigators are like, oh yeah, this sounds really exciting. And non-litigators are like, oh, I would never do that. But in fact, a lot of our pro bono attorneys are non-litigators. And because of the support and because it's not the same as a federal court procedures, a lot of non-litigators do go into court and they are successful and they learn a lot. And it's just really great experience. And I think it's something outside the box, but that we can prep you for.
And yeah, and everyone's like, oh my God, objections. Oh, I don't know how to do objections. And we're like, you need to know like relevance and foundation. And that's pretty much it. Otherwise you're good to go, So yeah, it's not scary and stressful in the same way that real court is. And it's, you can go beforehand and you can observe a merits hearing. So they're open to the court all the time. So a lot of times pro bonos like to go in beforehand. They like to watch a hearing because then they're like, oh, okay, I can tell, I got, not stressful. Yeah.
We find out information about the immigration justice, especially if that has some time. What are your two most places for that?
Yep, you can always call us because we, either talk to pro bonos who have cases. We have cases in front of different judges. There's been a lot of turnover in the court lately, so a lot of our judges have left recently, and we've gotten a batch full of new ones in. So we maybe don't have, tons of information on certain judges just because they're brand new. We also lately, the trend with a lot of these family unit cases that I mentioned is that they are they're using video teleconferencing. I don't know if you guys have heard about this recently too, but there are these random judges that they're pulling out of retirement that are in Texas or North Carolina or other places in these kind of centers, adjudication centers. And so basically the judge is appearing on a screen over here on the wall and you're looking at judge over here, your client is over here, you're directing, and it's been not awesome, I guess, is the basic experience so far for a couple people. I guess the audio has been fine, but it's been awkward and the judges have been described as brusque thus far. So, we keep records, we keep kind of rolling databases on the different judges. So we'll give you whatever information that we have. Mm-hmm. Great. Thanks.
That said, if you are interested and there's capacity to take cases, our next full training is going to be August 21st. Seyfarth Shaw will be hosting. And so you can see on our website, on our calendar on our website, or let me know if you have my email, or I can give you my email. It's right there, actually. If you're interested, Anna is actually also, whose email is right there, is registering people. So the 21st is a full 3 hour. We do ask that once you're trained that you take a case within 3 months. So it is limited space, and so there are webinars for those that might not be able to take a case but are still interested in the issue. Our next training then is August 21st. It is during the day from 11 to 2:30 at Seyfarth Shaw. Also, if you're interested in more kind of knowing what's going on in immigration issues, we do have a hot panel, hot topics in immigration on the 8th, and we will have former immigration judge Jenny Jambastiani who will be there, and a number of other really great advocates. One from Raiz is on the border who will be speaking, and then one of our senior litigators also will be moderating. And so that is August 8th. Actually, coincidentally, also at Seyfarth Shaw. It's through also with the support of the FBA. So all attorneys are invited to attend that. There's just lots going on, and I think it's a really great discussion that we're going to be having. Please register on the website also, or let me know and we'll get you registered.
Yeah, and I was just going to say, if you're interested and you're just curious what kind of cases we currently have in-house and pending and needing placement in homes with pro bono attorneys, we do have our case list online that kind of just gives you a basic summary of each of the individual cases to kind of let you know where clients are from, what their basic facts are, those kind of things. And if something's jumping out at you, by all means, let us know. Thanks so much.
Thank you. Thank you.